Hello, my name is Trevor Drury, Managing Director of Moorcraft Drury, and this is a short introductory video concerning the basics of mediation. What is mediation? Mediation is a form of alternative dispute resolution, or ADR. That is a voluntary, non-binding process used as an alternative to a dispute being determined by a third party, such as an adjudicator, arbitrator, or judge. It is flexible, can be quick and cost-effective if used at the right time. Whilst mediation is voluntary, the court should be the place of last resort for resolving disputes, and the civil procedure rules, i.e. those rules that set out how litigation is to be conducted, include pre-action protocols which require parties to attempt to mediate or use other forms of ADR to resolve their dispute. If a party refuses to mediate or use other forms of ADR, it runs the risk that in subsequent litigation the court will impose cost sanctions on the party that failed to participate in ADR. Unlike litigation, the parties have greater control and responsibility for resolving the dispute. Mediation is also private and is without prejudice to the parties' legal rights, and any settlement is confidential, unless expressly agreed otherwise in a settlement agreement. For example, a part of the settlement of a dispute may be a public statement or an apology. Mediation is conducted by a trained, truly neutral person who has no association or interest in the parties' affairs and who acts as a facilitator to help the parties hopefully reach their own negotiated settlement. The parties' faith in the mediator is fundamental to a successful outcome. The mediator will not be making a binding determination, and any settlement will be between the parties of their own volition. The process requires that both parties attend with the objective of hearing the other party's arguments and points of view, with a willingness to resolve the problem or disagreement by compromise. However, either party may withdraw from the process, and it is voluntary, and there is no mandatory requirement to reach a settlement. A frequent occurrence is that a resolution is not found on the day of the mediation, but shortly afterwards the parties negotiate a settlement. Any settlement agreement needs to be set down in writing and signed by the parties. Once there is a signed agreement, then that agreement is binding on the parties and can be enforced by the court like any other agreement. The without prejudice nature of mediation has the advantage of allowing the parties to disclose information, make and reject offers, express opinions, and make concessions in the knowledge that they cannot be disclosed and used in any subsequent litigation. I am an ADR Group accredited mediator and able to help parties arrive at a solution to any disagreement or dispute. Members of the Moorcraft Drury team also have experience of representing clients in mediation and have also attended mediations as expert witnesses. If you have any questions, please visit our website at www.moorcraft-drury.com or call us on 0117 313 1515.